manager pretrial since it started in 2017 under statute 3-1-708. And there is a copy of that statute in your packet that hopefully you were able to acquire. There's also a variety of other things in the packet. So like I said, hopefully it'll help as we go through this. Thank you again for participating, and a special thanks to Chief Judge Owen and Halligan and case managers Bill Van Horn and Greg Jacobson for helping the meetings get organized. It's been quite a long ordeal, so thank you for those folks. Dave McAlpin, our administrators, with us as in Helena, as well as Lisa, who's been with our program all along, Lisa Irvin. So today, Lisa just informed us that she's recording this for those that can't attend. Vicky's put up information in the chat box about CLE credits for the attorneys in the group. So that's important. Some of you know our trainer today, Dr. Michael Jones. Mike has supported the project since OCA was selected to do the public safety assessments by the Arnold Foundation way back in 2017. Mike's time and expertise was provided, like I said, by the Arnold Foundation to ensure Montana was fully trained and educated on the PSA. Mike's bio's in the packet as well. James Lopatka and Judge Beal are very familiar with Mike, as they've been involved with this from almost the beginning. James has from the beginning. Judge Holloway and Judge Beal been on our working and advisory committees all along, so thank you. Let me briefly explain why we are here today and why OCA decided it was important to provide this group, I guess, in a sense, a refresher course. A lot of you have been through some of the pretrial training, but it's been a while. And as we all know, there's some turnover. There's new judges, new prosecutors, new public defenders. So we felt that it would be important that we give the public safety assessment and pretrial a little refresher course. Dave McAlpin, our administrator, would like to add a few things, I believe, about his insight and why he feels today's training is important. So Dave, if you got a minute.
Yeah, thank you. I just want to acknowledge that we did go through some challenges during the last legislative session. There was a point at which the legislature cut the pretrial program out of the budget, and then through a lot of hard work, and I want to acknowledge James Lopatka's work talking to legislators, explaining the value of the program. We were able to get it put back in the budget, but we kind of sat down and took stock, and we realized that we probably need to do a better job of kind of telling the story of why pretrial is important, why it's ethically important, why it's in the criminal justice world, why it's important, and fiscally, why it's important. It saves counties dollars. You know, I just went down to award the grant to Lewis and Clark County, I think last week, and they measure this financially. And in Helena, Lewis and Clark County, they consider the program to save them $48,000 a day in the cost of incarceration. So that's just one of the parts. I don't want to minimize the human parts of pretrial, but there is a fiscal element. Yesterday, I talked to Justice Gustafson, who's always been a great advocate for pretrial, and just kind of closing the loop with her and about how can we do a better job of explaining pretrial and to be sure that we don't go through another session where there's some question or any question at all of its value. So part of that, kind of the outcome of all of this, is to try and go back to basics, be sure that we're providing good training. So thanks to Mike today, we're going to do some back to basics training. We realize there are new players, including myself, new judges involved, all that kind of justify some basic training. And then we'd like to follow up with some stakeholder meetings in the future to be sure we're all on the same team, that we're all articulating the reasons for pretrial and why it's a great program. So I did want to acknowledge we had our ups and downs where we went to the mat for pretrial. We were able to get it back in thanks to Senator Morshow and others. But it tells us that we need to work harder for next session to be sure it's just a no-brainer. The good news, the silver lining and all of that is through restoration of the pretrial into the budget, it was in fact converted to permanent ongoing funding. So as Mike will tell you, when it started, it was one-time only funding from the legislature that continued through this session when the program was funded as permanent and ongoing. So that opens up doors for us in expanding the program. We have other counties interested in it. Gallatin County has actually shown some interest in parts of our services being rendered down there. So lots of upsides. I don't want to just bring the doom and gloom here, but I want to tell you that we are aware of the challenges and we're committed to keeping the program funded and ongoing, but we're all going to have to work together on that. So thanks, Mike.
Thanks, Dave. That's great.
So
Again, our goal here today is to enhance your confidence in the public safety assessment and in pretrial program in general. There's an agenda in the packet, and with that, you can follow along with Mike's presentation and the other handouts. So with that said, Mike Jones, the screen is yours. Thank you.
All right. Well, good morning, everybody. I see we got lots from Lake and Missoula counties. So I have some slides today to share with you. A few of you may have seen a few of these 7.5 years ago, which is a long time. But I also have some new stuff too, because the pretrial field has evolved in terms of how we think about helping people to get back to court, stay out of trouble during pretrial release. And the way we talk about things and the way we present information and so forth. So as I go through today, if you have questions, please stop me if I can answer that pretty quickly. I will in a few minutes. If not, we can leave it till the end. And if that's still not good enough, of course, I'll commit to get back to you afterwards. Or if you're driving home today and you think of that question, email me or email Mike Farrader and he'll pass it along to me. Our emails are on the very last slide. So with that, I'm going to go ahead and share screen. All right, y'all see the blue slide? Yep, okay. And then I will also keep my chat open. I know some of you are tuning in just by Zoom with no camera. So if you want to ask a question, of course, be sure to come off mute. If you're asking a question and no one's responding, it's probably because you're muted. But come off mute. You can ask a question, wave your hand frantically so we see you. If not, you can go ahead and put something into the chat and we'll likely see that. But again, if not, just catch our attention and we will go from there. So, all right. So let's go ahead and get started. About legal and evidence-based pretrial practices in Montana. As Mike Farrader said, some of this is like a refresher for some of you. Others of I think you'll find some of this new and informative. So let me just ask you all real quick. We'll start off with a quick group participation. What would you say are kind of the main goals of the pretrial phase of the case, right? So between law enforcement contact to case disposition. So basically everything before sentencing or conviction and sentencing. What are we trying to achieve? What are the main goals?
People showing up for court and not being rearrested for new crimes.
All right, well said. Those are the two biggies. Thank you. James, I think that was you. It's dark, but that sounded like your voice. So thank you very much. Anybody else have anything? Any other goals you'd like to add to what James said? What we're trying to achieve. Oh, all right. Well, those are the two big.
I'm going to add something, Mike. I know that.
Yeah. Go ahead.
Managing jail population.
Okay, jail population is a consideration as well. All right, thanks. Well, if you look across the country, actually going back to about 400 AD Roman times, all through the Middle Ages, the Statute of Westminster, when the American colonies were founded in the 16 and 1700s. You know, as people came over from England, they brought with them English law, of course, and they made some adjustments for our new country and our constitution and so forth. And then the colonies and the states were formed all throughout that history. If you look across all of that, including up to today, we can kind of say we have three main goals of pretrial decision making. And we refer to those as the three M's because they all start with the letter M. And I think, and we put this picture up here so that you will remember it. And I hope you appreciate this picture because they usually only travel in pairs. Very hard to find three of them together. So our three goals of pretrial decision making are to simultaneously, one, and this was mentioned by you all just a few minutes ago, maximize court appearance, right? We want as many people to attend as many court hearings, right? Obviously, 100%, if we measured this and got 100%, that would be a perfect score. We also want to maximize public safety and law-abiding behavior during pretrial release, right? So people are accused of a crime, they're often booked into jail. If they're released pretrial, we want them to behave themselves during pretrial release, right? That is a condition of their release. And I believe you all have that one in statute as well. That's automatic. Judges cannot unorder that as a condition of their bond or their release. They have to behave themselves as well as come back to all their court hearings for which they have to appear. And then thirdly, the third M, this is what Mike Farrader was getting at, we want to maximize pretrial release and liberty and minimize detention while doing the other two. So you can see these different goals. It's a balancing act. And I've always thought judges have the toughest job of everyone, justices of the peace, simply because they have to balance the liberty interests of the individual, right? The right to freedom that we enjoy as Americans when we're, you know, especially as we're unconvicted, right? We're not yet convicted of a crime, with the government's interests of maintaining law and order, to administer a justice system, and we do that right by people coming to court and staying out of trouble. So prosecution and defense, not an easy job, of course, but slightly easier in this regard because they can choose to focus on some of these goals more than the others, whereas judges always have to balance them and do that balancing test. So if you remember anything today, it would be this item plus one other that we'll get to shortly. So those are the three goals that simultaneously, if we can get as high of a grade or metrics on all three of these, we will have a very fair and effective pretrial system. So how has Montana been doing on those three M's? So your OCA staff collects a lot of data and assembles it and has it in their case management system there. So basically from summer last year to summer this past year, 5 counties all averaged together, weighted of course by volume, because Lake County would contribute the fewest cases because it's a smaller jurisdiction, and like Yellowstone, Missoula, Lewis and Clark are larger, so they have more case volume. Here's how Montana did on those three M's. So the overall kind of average court appearance rate was about 76%. That means those people came to court and was not issued a warrant for FTA for arrest and so forth. So about 3 out of 4 people did what we wanted them to do. So that's really good news. Law-abiding behavior, not picking up new charges during pretrial release, of those people released was almost 7 out of 10, so 68%. And that's any kind of criminal offense. That could be a misdemeanor, felony, it could be violent, non-violent, all the way down to public order. As long as something was jailable, it was counted in this metric. And a subtype of that were, well, how many of those were like violent, non-violent? And good news is when people messed up, most of the time, 88%, it was for a non-violent new offense.
Mike, can I just ask you if the DUI
please.
counts as a violent offense?
I believe it does, unless there's injury to a person. It's typically not a violent offense. Unless you have one of those parts of, it's possible that, and I just don't remember, it's been a long time, sorry. I do remember though, when Montana put together the violent offense list for scoring the PSA and calculating these metrics, there were certain subsections of different offenses that made the violent list and some didn't because the way statute was worded. So it is possible that some of the DUI subsections, if you have some, are violent and some aren't. I just don't remember. I remember that was true, I think, for robbery, where some were, some weren't, based on how, and that's true in most states. You got to kind of look at the subsection codes. And then lastly, pretrial release. This is people being released on pretrial status before their case reaches disposition. Whatever that disposition may be, is about 7 out of 10 people. So again, you're pretty high on these metrics. The goal, of course, is great. How do we balance? How do we get 1 and 2 a little higher while also getting 3 a little higher? And it is possible. And that's one of the reasons why the Supreme Court back in 2017 started this project that we're talking about today and created the pretrial resource at OCA as well as in the localities. All right, let's move on. So for the pretrial phase, just kind of 3 themes to think about. Some of this is new. I do recall we had a little bit of research back in 2017 and 18 when we rolled this out statewide in Montana. But there has been a little bit new developments in thinking in the field in terms of best practices. One of them, the research is we have some pretty solid research now that pretrial detention for more than 1 day causes harm to short and long-term law-abiding behavior and public safety. So said differently, when someone's booked into a jail, we know that some people are very dangerous and the court will detain them pre-trial, right? That's part of that balancing test. We don't think we can assure public safety, and one of the tools we have at our disposal, pre-trial detention, seems like the best option for some of those cases. But for everybody else, if they're released, it behooves us to get them out of jail as fast as possible if we're going to release them. There's now research showing that if we delay pretrial release for people who are released, even 2 or even 3, as little as 2 or 3 days, and then it just starts to magnify at 4, 7, 14, up to a month later, say it takes them that long to get out of jail and pretrial release for whatever reason, that they are less likely to abide by the law during pretrial release. So we actually, when we delay pretrial release, we're actually causing the thing we're trying to prevent. So big picture, it makes sense that if somebody's booked into jail, we make a decision as quickly as possible to say either that person is staying in the jail or they're getting out by tomorrow. That's what makes the most sense. And trying to make court orders such that that release is expedited as quickly as possible. And the researchers who have studied this are like, well, because when people are in jail, it's not really a good place for folks, especially people with behavioral health issues and so forth. And so we tend to destabilize them, their housing, their employment, they can lose their jobs, and all that can contribute to additional criminal behavior. All right, so moving on. Another theme that's come up a lot in the past few years is less is more. And this is especially true around pretrial release conditions. There is a nationwide tendency, so it probably exists in Montana, that we often have the mindset of, well, let's order this condition and that condition, right? It can only help. Hopefully it's, let's hedge our bets. But research is showing that the less we do to people, the better they fare. Or by adding more, we're not getting better results. That doesn't mean do nothing, and we'll talk about that in a little bit, but there is a tendency to, I would say, by quite a large margin, to over-condition people on pretrial release, as well as to over-supervise them. Again, it doesn't mean don't do those things. It just means we want to start with the assumption that we're going to do nothing to people released, right? That's the least restrictive condition principle. And only add those things if we think it will help this specific individual with their specific life situation. So we're starting to get an increasing amount of research showing that. And then related to that is pretrial services is not probation. I've encountered a number of people throughout the country, including one in Montana a couple months back, who said, we put more conditions and restrictions on our pretrial defendants than we do our sentenced probationers. And that just seems a little backwards. And we get where they're coming from, right? As these people are presumed innocent, we should be individualized and least restrictive with our conditioning. And what we do to them might have a little bit in common with probation, but it should look quite different. Or another way to say that is any of us should be able to sit in a meeting between, say, a pretrial case manager and a pretrial defendant, and then sit in another meeting with, say, a probation officer and the probationer, and it should look very different on what they talk about, how they talk about it, and how they interact. Doesn't mean that probation entities cannot perform pretrial services. That's pretty common throughout the country. It just means that you need to have a different mindset and some specialized training so it doesn't look like pretrial probation, so to speak. So those are kind of the things that have really been coming up since the last time we've met. So let's get in now to some assessment tools and risk. All right, so I just saw a question in the chat. Is that causation or correlation? Was that around detention causing pretrial failure?
Yeah, I just wonder if there's
Okay.
something about the population of people who are incarcerated for 2 weeks or a month and then get out. Are they already predisposed to getting in trouble? And it's not actually the incarceration causing them to perform more poorly. It's just that they
Right.
were.
Yes, worse off to
Yeah.
begin with. Yeah, that's fair. No, great question. And so, yes, that's obviously important to ask. And so what researchers have been doing over the past, I'd say especially since 2016 through 2020 is when this research really started to come out, is they do statistical controls so that we can make those causal inferences. To be able to say that, no, it's actually when we have two similarly situated groups and we control for those competing explanations, and there's different ways to do that through social sciences, as some of you know, that we're actually seeing the more we delay the release, the more those people tend to fail. Compared to people who say get out quickly. So to answer your question, it's more on the causation than correlation side. And you're right, we do have to pay attention to that. All right, assessment tools and risk. So why do we do pretrial assessment? What might you say? Is anybody? Put it in the chat.
To group defendants into different categories so we can compare the likelihood of their performance amongst other people in their cohort.
Yeah, there you go. Well said. All right. I think James read the Cliff Notes to some of this content today. But yes, exactly. So why are we doing assessment? Is we are making predictions about people. And then, yes, we'll see shortly, once we make predictions about all these people, we tend to put them into little groups or buckets so that we do different things with them and how we allocate our resources. So it's all about prediction, right? Because these people are booked into jail. We don't know much about them, right? We know what they're charged with. We might have the arresting officer's statement. We might have, the PSA, which gives their statistical risk. And again, we'll see that in a moment. But that's about it. And we got to make a decision. Is this person going to stay in jail or are they going to get out? And if they get out, how do we support that person to come back to court and abide by the law? Because that's what we want them to do. So as was said, it helps us identify who's more or less likely to succeed or fail. And when we know that, it gives us the chance to intervene with people before failure occurs. There are models out there. I haven't encountered it, and I'm going to guess I never will, because this is a pretty big leap for just about all of us. That there's a model that says, what we could do is once we book people into jail, we could just release all of them, see how they do, and if they fail, then we'll respond to things like supervision or drug testing or electronic monitoring. And that sounds kind of silly until you look at the statistics, and it seems, I'll just say, less silly. When you go, well, we also know that we probably won't be interacting with, give or take, 70–80% of those people. It'll only be 20 or 30 that will actually fail, and then we respond to. But nonetheless, I'm not advocating for that approach. That's what we call a non-prediction model, We actually don't make a prediction. We release just about everybody, and then we see how they do and respond to that. So, if you find out a jurisdiction that goes with that model, let me know. That would be fascinating to study. All right, so let's talk a little bit about actuarial pretrial assessment tools. All actuarial means is it's statistically based, right? It's based on data analysis and numbers to predict. And so we have a lot of tools used across the United States in pretrial. You know about the PSA, or Public Safety Assessment, that's used in Montana. We have others in Virginia that's used statewide, although they are in the process of converting to the PSA. A few colleagues of mine and I have been helping them out with that. We have ORAS is in Ohio, the CPAT's in Colorado, where I'm from, and then the Petra is in Montana, in every state, because that's in our federal court system. That's the federal court's risk assessment tool. And actuarial prediction exists in many non-pretrial industries. Of course, it exists in other parts of the criminal justice system, but it exists in healthcare, education, business, transportation. It's based anywhere where we can use data to try to make predictions about how things are going to turn out or how people are going to behave, gives us an opportunity to hopefully better the human condition. So it's used quite commonly. It's just been used in the pretrial field in the actuarial sense since around the late 90s to the turn of the century. So almost about 30 years now. And we use research-based factors to predict the likelihood of pretrial success. Who's going to come to court and stay out of trouble? The big difference is the other method of doing prediction, and that's just our gut hunches and subjective interpretation of whatever information we have available. So that's things like we can look at somebody's charge, we can look at their criminal history, we can ask questions, we can look at the officer's report, and we can somehow put all that together in our head and make our best guess. And that's not bad or wrong, because we do it all the time. It's just that it's less accurate than the statistics. And that data has been shown over many, many decades in many fields, including criminal justice, is we are just not as consistent and as accurate as the computer, because it weighs all that information exactly the same for every person, something that we could never do. And it knows how to weight that different information, some a little stronger, some a little weaker. And we'll see that in a moment. And so statistical prediction, again, just augments our pretrial decision making. We don't want to just look at the statistical prediction and blindly follow it. But it is best practice, and we get better results. Think of the 3 M's when we use that in conjunction with our professional judgment and decision making. All right, so let's move on to what these tools measure. So they answer 2 important questions. Again, I offer to you, this is the second thing, if you remember anything from today, it's how to think about risk. Because if I said, for example, that Dave McAlpin guy, some of us just met him today, he's risky. What do most people hear or infer from that? What would you say? I haven't met this McAlpin guy, but I know he's risky.
Sounds shady. I want a high bond.
Shady high bond. Okay. All right. So we make an inference and then what to do about it. So thanks. That's very common. So I offer to you this. When you hear the word risk or risky, whether it's in your mind, you're thinking it, or you hear somebody say it, I suggest you answer 2 super important questions. The first question is, ask yourself, risk of what? What is the person at risk of? Because all you heard was he was risky. The second question is, okay, now that I know what risk we're talking about, how much of it? What is the amount of risk? So you see, a lot of us are just a little simplistic at times, right? Our human brains like to take shortcuts. When we hear the word risk, we often go to what was just mentioned a few minutes ago. Oh, risky means like high risk, dangerous, bad, take caution, I need to do something. but it doesn't really mean that. It's a very neutral word. And we have to ask ourselves, okay, risky. What is the person at risk of and how much of it? If you ask those two questions, I am sure you will arrive at more thoughtful, effective, and fair pretrial decision making. So it's important to always keep both in mind. So let's look at that in a little bit more detail. The risk of what question? What are the different types of pretrial failure that we see when people, they're not doing what they're supposed to? Someone put it in the chat or come off mute. Different types of pretrial failure.
I know from my experience here, I just continue to hear about people that don't show up for court and how it bogs things down in the system.
All right, yep, they're supposed to show up for the hearing and they don't. So we call that, yeah, FTA, failure to appear or non-appearance. Yep, that's one type. Someone throw out another one. Let's see.
They commit other crimes
Yep.
or they
Yeah.
otherwise violate conditions of their release.
Yep, okay, yes, thank you. Yes, they can break the law, get arrested again. That wasn't supposed to happen, right? We want law-abiding behavior. And of course, they could violate a court order condition, which we often refer to as a technical violation. It's not necessarily a new law violation or a failure to appear, but they didn't do what the court told them to do. So, yep, you mentioned several of those. So here's some common pretrial failures. I list some of these separately because some of these are actually different than others. And it's important to keep that in mind. Let's just look at the first two. There is a big difference, legal scholars have written, between FTA, failure to appear, and flight. They often define FTA as just what it sounds like. You're supposed to show up and you didn't, but we don't exactly know why. It could be a myriad of reasons. It could be because you didn't feel like it or you didn't want to go. It could have been because you didn't go because you were scared of what might happen. It could go because you couldn't get transportation. That's not uncommon, especially in rural areas and very large geographic counties or ones with mountains like we both have here in our states. You can't get off work. So the person's actually making a calculated choice. I can go to court, which I'm pretty sure I'm supposed to do, or I could not go to work and I'll probably get fired for some people in some of their jobs. And so there's a lot of different reasons. Of course, the biggie, they just forget or they get confused or they go to the wrong courthouse. They went to this courthouse, not that one. That's on the other side of town and so forth. So a lot of different reasons why people FTA. Legal scholars will define flight as it's actually technically a subcategory of FTA, but it's one in which somebody actually packs their bags and leaves town and they're trying to avoid prosecution. So if they lived in Polson, they have left Polson, gone somewhere else. Maybe it's somewhere else in the state, maybe it's Idaho, maybe it's Canada, whatever. They're trying not to get caught. That's flight. The reason it's important to know this distinction is flight happens, but it's very, very rare statistically. It's almost like lightning strikes. It happens, but it doesn't happen everywhere all the time, right? Most of the time it's just rain. And that's how failure to appear in flight are. So it would be improper or inaccurate to say that, ooh, somebody scored high on the PSA, which we'll see in a moment, therefore they're a flight risk. No, they're just a FTA risk. Keep in mind, you could be a high FTA risk, but a low flight risk, right? And in fact, most people who fail to appear, we catch them. And it's usually the cops. And they're usually in town, whether they're just going about their lives or they're actually subtly trying not to get caught. But we usually find them around town, at work, at home, and so forth. They actually haven't fled the jurisdiction. Similar between 3 and 4, new arrest for any offense. Again, that's just how it sounds. It's anything. It could be misdemeanor, felony, person, property, crime, person, property, drug, driving, public order. it's a new arrest for any of those, or we could break it out and say, well, we're really interested in the violent stuff, right? Whether it's domestic or stranger and so forth. So we could look at that breakout as well. But of course, if someone scores high on certain scores on the PSA, it doesn't mean they're dangerous. It just means that they might have an increased statistical probability of being arrested for any new offense, not necessarily a violent one. And then lastly, of course, was mentioned technical violation. That's not following court orders. So it's important to know that your PSA tool and all other tools like them, Virginia, Ohio, Colorado, New York, they only measure people's statistical risk for numbers 1 and 3. So the PSA does not measure flight, it's just FTA, and it measures new arrests for any offense. Except the PSA is the only tool in the USA that also does number 4. It actually gives 3 predictions for people that we assess with the PSA. So it actually lets us know people's likelihood of FTA, new arrest, and a new violent arrest, or arrest for a violent offense. Other tools don't do number 4. So again, you can see here, we've just answered the risk of what question. The PSA answers that. This person is at risk of these things. That's risk of what? What the PSA also does, and this is where just our minds would have to guess, but this is statistical prediction, so it's relatively pretty accurate, and that's true in Montana. Risk is not an either or thing. We can view it as a continuum or scale. So we got a little scale here. Anyone want to guess why it goes from 1 to 99 and not 0 to 100? When we're talking about how risky somebody might be. Why not 0 or 100? Why 1 to 99?
It only Siths deal in absolutes.
Okay, yes, absolutes, right. Because here, this is very unlikely. 1% likely to fail pretrial. And the reason for that is there's no such thing as no risk. So earlier when I said that Dave guy, he's risky, I was 100% right because he is risky. He's not no risk. It's impossible to be no risk. Every defendant who comes before any Montana court is risky. It's just a question of what and how much. Conversely, every defendant that comes from Montana courts is not guaranteed to fail. In fact, no individual person is guaranteed to fail. You will find, and we'll see this in a moment, the PSA, even people with serious charges, longer criminal histories, several past FTAs, maybe they've been in jail before or prison. They have other cases pending in other counties and so forth. Even a good number of those people, if they were to be released pretrial, they behave themselves. They're not all going to fail just because it looks dire on paper. So that was correct. Not absolutes. There's no such thing as no risk, and there's no such thing as guaranteed failure. In fact, I would say if all of us today somehow picked up some kind of criminal offense, maybe it's criminal traffic, maybe it's a low-level misdemeanor, every one of us is at risk of FTA, for example. Because we might have court next week, maybe it's next month, a couple months down the road. Like, stuff happens, right? Maybe the car breaks down. Maybe we have that crazy snowstorm, can't get over the pass. Maybe we forget or get confused. Whatever it is. Every one of us, even though most of us are probably fairly responsible, law-abiding citizens, and value the system, we are at risk of FTA if we were to pick up a case. Now, we might be really, really low. But see, we've answered the question, risk of what and how much. So I just offer to you in sum that it is not really helpful to talk about people being risky or not risky. That kind of black and white thinking makes it harder to allocate our limited resources towards those people for whom we are thinking, what are they actually at risk of and how much risk is there? And then is there something we can do about that to bring that specific risk down? That would be the best practice. All right, so let's look at your assessment report. Those of you who have been getting the reports from OCA will recognize this. We just have an example here. This is like the top of the report, right? It's got the person's name, their arrest date, what they're charged with currently, why they were booked into jail. It gives also, of course, their date of birth. And this is what your OCA processors prepare and send it and then upload it back to the system. This is the rest of the report. I'll show you a few sections of this. The assessment information in the middle, that is required for transparency purposes, just to let anyone knowing the report and say, we're talking about somebody's statistical risk. This is how they scored on the PSA. Here's the 9 factors. And we'll talk about those. I have another slide for that in a moment, but that's in that middle section. It transparently shows, oh, the PSA is saying this person got this score on the PSA. Where does that come from, right? What did the PSA consider? Did it say yes or no for certain items? When it counted the number of things, was it 1, 2, 3, or 4 things that it counted? And again, this would be something that would be nearly impossible for any human being to articulate and say, oh yeah, I went down the 9 factors, and when I thought about John Smith, these are the 9, not how I graded or scored him on those 9 things. So it's consistent and transparent. The very top there gives those 3 outputs of the PSA. What are they at risk of? And so FTA, this person got a 6. We'll talk about what that means in a second for those of you who don't quite know. NCA, new criminal activity or arrest. This person got a 6. And then lastly, remember the PSA gives us that 3rd score, new violent criminal arrest or activity, NVCA, to use an acronym. This person got a yes, because that's expressed as a yes-no flag. So you go, okay, that's what they're at risk of, and they got a 6. That's telling me how much risk, but what exactly does a 6 mean? A few weeks ago, earlier this month, OCA processors started putting the information you see down here at the bottom in the notes. They tell us what the scores mean in Montana based on Montana defendants' data. So if you see, for example, up at the top left where it said, all right, this guy got an FTA 6. What the heck does that mean, right? There's no context, there's no scale to that, no meaning right now. So we look at the bottom and go, oh, FTA 6 in Montana means 65% likely to appear. Does somebody have a question? No.
Mike,
Okay.
how recently has that been updated? I know that
Ye-
those were the numbers we had back in 2021, but I
Yeah,
wondered if
20,
they've
yeah.
shifted over time.
Yep, and they will shift somewhat over time, and that is still those data. OCA is looking at now how it might update those data. So thanks for asking that question to say, hey, how do we bring that up to say like 2025? Because that would be a good thing to do is every several years, just go through and do like perhaps a running 5-year average, like the last 5 years. What do the numbers look like? I can, for example, the state of Virginia is doing that as we speak. They've had data and they've been doing actuarial assessments since I think about 2002. So they've had this data now for about 23 years. Now they're switching to the PSA, so they want to use the PSA metrics, and they're going through now their state data. So, and they have pretty advanced data system in Virginia, one of the few states that does, where they can actually look at hundreds of thousands of people released and ask the question, of all these people released, how did they do? Did they show up to court? Did they pick up new charges? Yes or no? And then what was their PSA score? And then they can map their performance to those scores, and their percentages, like you can be calculated.
James, I did
Okay.
see that 2021. It concerned me as well. So I am meeting with Mike. I've talked with Dave. We're going to seriously look at updating that. So I believe that will happen. So thanks for the question.
Yeah, thank you. Agreed. Thanks, Mike. And yeah, and I'll show you in just a moment. I have a slide for you can see like all the scores at once in one slide. You go, okay, FTA 6, 65% likely to appear. That is basically saying people in Montana who got an FTA score of 6, 2 out of 3 of them do the thing we want them to do. 1 out of 3 do not. So the question is, what can we do to bring that performance up for that group of people, the people who score sixes. And there are some things you can do. And then lastly, we have this last section, for those of you who aren't familiar, presumptive release conditions. Based on how this person scored, this person at level 3, and we'll show you where that comes from. That's a document called the Pretrial Release Guide that Montana came up with. All right, so a little bit about the public safety assessment, since we typically have questions about that. And again, if you have questions in the chat, okay. Okay, good. Yep, all right. Thank you. I had my chat on the wrong setting. Now I'm seeing some of the questions that have come in. Yes, so I saw the question about willful, non-willful FTA, and that was the correct answer. No, it's just an FTA for any reason. It could be willful, non-willful. It could be because you forgot. It could be, again, you just didn't want to go and want to take your chances. It could be because you didn't understand, you got confused. There are all kinds of information. Sometimes the court messes up and it gives people the wrong date on their paperwork. We've seen that one as well. So it's an FTA for any reason. But you can see the court can always think about that in its decision making, right? The defense can bring it up if they're at the hearing, prosecution can make their arguments, and the judge decides and say, look, you were supposed to show, we issue a warrant, we brought you back in, what's going on, and make the best decision you got. All right, so the PSA, let's talk about that. Here are those 9 factors. And you'll see there's a 2A and 5A in that left column. We call that a subfactor because it's calculated from the couple above it. But we have 9 different unique factors on the PSA. And we have the 3 outcomes it predicts: FTA, NCA, new criminal arrest, new violent criminal arrest. Anyone want to guess why there's a check mark in some of those boxes under the outcomes for the different factors? Why do we have some check marks and some blank? Any guesses? We got a quiet group today, except for Impulsive. Yes.
Because some of that information is statistically significant only to one or the other.
Yes, well said. Information considered. Yeah, thank you, Shane. So yes, it's because that factor, where the numbered factors on the left, statistically predicts that outcome. It doesn't predict the other outcomes. So if there's a check mark, it means through statistical analysis of hundreds of thousands of cases when the PSA was constructed, that they found that, for example, age at current arrest predicted new criminal arrest. It did not predict FTA. So the age of the defendant didn't matter. A few other ones you'll notice. Let's look at 7 and 8. Prior FTAs, surely they predict future FTA. Well, yeah, past is predicting future there. But you'll see the PSA researchers were able to break it down. So if there was a prior, number 7, prior FTA in the past 2 years, that predicted FTA in this case, but it also predicted new arrest. I wouldn't have guessed that, right? That's an example of where statistical prediction can answer questions that our brains can't or wouldn't think of. I would not have guessed that somebody had an FTA in the past 2 years was also a little bit more likely to pick up a new case. That's interesting to me. I can't explain why. We might be able to come up with some explanations, but however, older FTAs only predicted FTA, not new arrest. I wouldn't have guessed that the age of an FTA made that much of a difference for predicting new arrest, but it did statistically. So that's how you read, this chart here. I'll just ask, what would you say is our all-star factor? Which bit of information about the defendant is sort of the all-star predictor, if you will?
Number 3.
Yeah, number 3. Yeah, thank you. Pending charge at the time of arrest, it predicted all 3 outcomes statistically. So that's just having another open case. So it's you've gone to court. It's in pretrial status, not probation or post sentence. And the case is pending disposition, and it could be your county or a different county, it can be a different state. That just having that open case makes you more likely to FTA, pick up a new arrest, and actually a new violent arrest, and that's no matter what you were charged with. So again, it's just kind of interesting. A long time ago, a statistical expert, I asked him, I was like, why are some things predictive and not others? Like this, some of these make sense to me and some of them just don't. And he said, that's just the way it is. We're talking about human behavior, and sometimes things are intuitive and sometimes they're not. That's a separate calculus than if something statistically predicts or it doesn't statistically predict. Because sometimes we know why, sometimes we don't. It just does or it just doesn't.
Like, is there still cognitive bias through the PSA? Can we eliminate cognitive bias through this?
I think to a point, the purpose of doing the PSA is a couple fold. One is it makes our predictions more consistent because we're looking at these 9 things for everybody, right? So no matter how we feel that day, good day, bad day, it's cold outside, it's hot outside, we're hungry, we're full, we're tired, we're energetic, all those human things that we just naturally have as people, don't impact this scoring, right? It scores the same people the same way all the time, no matter what county you're in, who the judge, the prosecutor, defense attorney, the PSA processor, it gets scored the same way all the time. The other thing is just with the accuracy of prediction, which we talked about. So we tend to be more accurate when looking at the things that statistically predict than entering in the stuff that we think predicts. And it's not that we're necessarily wrong. A question that often comes up here, Dave, is people go, all right, I get these 9 things, but why aren't these other 4 things on this list? The answer to that is most often, when the researchers looked at the hundreds of factors that jurisdictions can or do think about when predicting pretrial failure, they put all that data into the computer and they simply just asked the question in the code, computer programming code, just what statistically predicts. And this is the output of what was left. So that means that all those other things, those dozens of factors, either weren't predictive, even though our intuition says they seem like they should be, or they were predictive, our intuition was spot on, but they were so weak that once we knew the stronger predictors, it kind of washed out the weaker ones. It provided no additive value. So the other thing I'll say about this is look at NVCA. There's a tendency, I think for a lot of us to say, well, if someone's charged with a current violent offense, they're more likely to do a violent offense if they were released pre-trial. And that is statistically true, because see, we got the check mark here. But what we also need to keep in mind is your current offense being violent or not is only one of 5 predictors. So it predicts, but by itself, it's pretty weak. We need to look at kind of the whole case or the whole person, so to speak. In fact, I was in Virginia last week, and we had a case. I'm sure the PSA processors have seen it because they've done tens of thousands of these scoring by now. Is this person actually did not have a violent offense, but they had the yes on the flag because they had these other things. And see, that's something that my brain would not have guessed. I would not have guessed somebody with a pending charge. They had a pending charge and they had some prior convictions and a couple prior violent convictions, but their current offense was like theft or larceny or something. So, all right. All right, so let's move on. And then, yes, I saw in the chat about it would be nice to be able to predict DUI. It's pretty common wherever you go across the country that people say, you know, the cases that tend to give us the most heartburn are DUIs and domestic, because they just seem to have a lot going on, and the stakes are pretty high. if they mess up again in those ways. And so I agree. It's just we don't have that kind of prediction yet. But that doesn't mean there's not things we can't do about it. In fact, a lot of DV defendants, they'll score yes on this factor, correct violent offense, and they may or may not have some of these other ones. The people who have these other attributes are at higher risk than the people who don't.
As James knows, when we developed, he was a big part of developing the pretrial release guide. In Montana, our group insisted that the DUIs be bumped up to a higher level, as well as domestic violence. That's how we kind of overcame that concern. So you might score 1, but our guide bumps them up to at least a level 2.
Yeah,
And
which means
that was the work of that group.
Yeah, thanks, Mike. Which means we'll get supervision, so we'll see that shortly.
Right.
So here's briefly what all the scores mean. This is what those little bullet points in the notes section of your PSA reports will show. So for example, we already saw FTA 6 there at the bottom. The people who got FTA score of 6, 65% of those people had no FTA. That means 35% did. And then you can see as the scores got better looking on the FTA scale, right? Because a score of 1 is the best score you can get. 6, if you will, is the worst score or higher risk. You can see that the performance goes up. So the way to read this is pretty simple. People in Montana who get an FTA score of 1, 93% of the time, those people will come back to court, do what we want, no warrants for the rest, 7% won't. But see, there's a great example, right? The people who are the lowest risk in Montana, and by the way, your data looks very similar to national averages in almost any other state that's done these kind of analyses. They have the same pattern where kind of success goes down as the score goes up. It's like stair steps. But no one's at 99 or 100. I think the best I've seen is pretty close to here, 93, 94. So remember, there's no such thing as no risk. Even people with nonviolent charges, no FTA history, no other cases going on. They haven't been in jail, no convictions, they're older, they're getting like no points on the PSA. 7 out of 100 of them will still fail to appear in Montana, right? No such thing as no risk. And as you see on the bottom, no such thing as guaranteed failure. Those people who score a 6, you have to have quite a bit going on in your history to get a 6, right? Usually it's previous FTAs, you might have previous convictions, other pending cases, and so forth. But even 2 out of those 3 people do what we want them to do. They come back to court, right? No such thing as guaranteed failure. So that's where the data comes from on the pretrial report. Similar pattern, I won't go over this line by line for new criminal arrest. So these are the percent of people based on their PSA scores that remain arrest-free in Montana. And again, your data is pretty similar. So you can see the middle group is right around that 70, 80 something percent. And then some people fail a little more than that, some people a little less. And then lastly, the violence flag. A lot of people ask about this one. So how to read this is, remember, some people get the flag yes or no. It's important not to overreact when you see the flag. And I would say maybe judges and attorneys might not, but the public and the media would probably need some education like we're talking about today. Feel free to reuse any of these slides because they're going to be like, wait a minute, you let a guy out of jail who had a violent flag of yes? Are you kidding me? And the answer is, well, let's look at the statistics. What does a yes flag mean? It doesn't mean that they're going to be violent or dangerous. It just means that's the risk of what? How risky are they? So in Montana, if you do not have the flag, 96% of the time they were not arrested for a new violent offense during pretrial release. If they had the flag, the green chart or the green bar, 9 out of 10 times they were not arrested for a new violent offense. 1 out of 10 they were. So said differently, if we lined up 100 defendants in Montana today who all had the flag, and if we released all of them, About 10 of them will get picked up for a new violent offense, 90 won't, give or take. So you could see, we wouldn't want to do, for example, be overly simplistic and say automatically, this is why we got to look at each case individually, right? Hear from the prosecution, the defense, and the facts and circumstances, and go, oh, if they have a yes flag, I'm keeping these people in jail. Because to do that in Montana, you're basically, you would have to put 100 people in jail just to be right 10 times. And just, I don't know if that's right or wrong or good or bad, but you have to decide if that passes legal muster or the balancing test. You know, can we take away people's right to liberty 100 times just to be right 10 times? So that's just to say the flag is one piece of information. It shouldn't be the primary driver. All right, let's move on. Sometimes we ask, well, how often does the flag happen? Again, more good news. It's about a quarter of the time of the people booked into Montana jails and the data we analyzed had the flag, and about 3/4 did not have the flag. So it's not that common to have the flag, fortunately. And even of those with the flag, most of them do what we want them to do, if they're released. Obviously, some of them won't. And some people without the flag will be held in jail because we look at the whole case. All right. So most people succeed on pretrial release. Again, national average is pretty close to 80%. You're right in that ballpark. And if people mess up, it's almost never for a new violent offense. It's generally in that 3, 5, maybe 8% range. So good news for public safety. So let's talk briefly about pretrial release conditions. All right, I guess if you remember a third thing today, this is the last you'll have to remember. A great thing to do is always, this is putting the 3 M's into practical everyday use. If you have any release condition, always ask yourself, how does it hold up to the 3 M's? What data and research do we have? To what extent does it help maximize court appearance? Does it help with law-abiding behavior? And does it maximize release and liberty? Because remember, our goal is to get the most of all 3 of these at the same time. So when we impose release conditions, we want to hold them to that same standard. We want any condition of release, be it supervision, drug testing, electronic monitoring, no contact order, don't leave the state, whatever it may be. We can always ask ourselves, well, how does that help with court appearance? How does that help with law abiding? And does it maximize people's release, not just from jail, but to minimize the restrictions placed on their freedom and liberty and movement? All simultaneous goals. So if anyone comes to you saying, this is a great release condition to use, you can go, okay, tell me some more, and hold it up to the 3 M's. And I offer to you that if you do that, you will be well down the road of being evidence-based. All right, so here's a real quick chart put together a few years ago. I don't think you all have seen this one yet. On the left is some of the most common kinds of pretrial release conditions that a lot of states use. This is where we actually have research from a number of jurisdictions across the country over years. So court date notifications, that's the reminders, right? The text, the email that says, come back to court. Pretrial services, checking in, the case manager, you all know what that is. Drug and alcohol testing, that's all the types combined here. Electronic location, right? That's GPS, satellite tracking, so forth. And then, of course, secured financial conditions, what we might call cash or surety bail, right? You got to pay money to get out of jail. How do these are all conditions, right? That we can condition people's release from custody, that they need to do these things. So how do they hold up to the 3 M's? Those are our 3 columns. Here's how reminders do. We have a lot of solid research that shows it gets people back to court. In fact, if you do any one thing in the state of Montana to help improve your court appearance, it would be send them behaviorally designed reminders, because they work. I mean, we all get them, right? For our doctor's appointments, our restaurant reservations, maybe when your library card is due, renew some insurance policy. We all get reminders all the time because they just work. They're ubiquitous in our society nowadays. And that can come again in the form of text messages. It could be a phone call. It could be a robocall or live person. It could be an email. It could be a letter or a postcard, some combination, but they are really, really effective. In fact, I saw one study that showed that people actually have a higher FTA rate for doctor's appointments than criminal defendants for their court hearings. I wouldn't have guessed that, but that fascinates me. That's why doctors send us the reminders, right? Because it costs everybody a lot of money when we don't show, just like FTAs. How does it work for arrest-free behavior? We don't know. No one's actually studied that. We haven't sent text messages that remind people to follow the law. Maybe it would work, maybe it wouldn't. I'd be surprised if it did, based on human psychology. And then lastly, how does it maximize release liberty? Again, good green check mark, because it's minimal onerousness on people's liberty and freedom for them just to get a letter or an email or their phone buzzes with a text message. So again, scores very well on the 3 M's. How does pretrial services and check-ins do? Again, we have research that shows it gets people back to court. Research so far in the second column has failed to show that it reduces pretrial law-abiding behavior. Or I should say, sorry, it doesn't increase law-abiding behavior. It doesn't reduce crime. And then lastly, it's pretty non-restrictive for the most part. Especially if we do what a lot of places are doing nowadays, especially since COVID, is they do telephone or video conference contacts primarily. They might meet with the person once individually in person, but then all subsequent check-ins and contacts are done, over the phone. They're getting great compliance with that. So again, minimal restriction. The asterisk in that first column is pretrial services doesn't work the same for everybody. It tends to work best for people who have higher PSA scores and have no effect or actually make worse people who are in the lower PSA score group. And your working group and advisory committee back in 2018 thought about this research when they designed their pretrial release guide, which we'll see in a moment. So again, it doesn't work the same for everybody. Put another way, you can think of things like pretrial services and supervision as like medicine, right? If you give a sick person medicine, that'll probably make them a little bit better. If you give medicine to a healthy person, it's not going to make them healthier. So that's a good example of where less is more. Putting people who are already going to do well on supervision will either have no effect or it can actually make them FTA more or pick up new offenses because we inconvenience them, we destabilize them, we put conditions and requirements upon them that they don't need and that they have to sort of like if they're just barely hanging on with life, with whatever their life situation is, with housing and employment, family stability especially, and we destabilize that, we actually can make them more criminogenic. All right, how does drug and alcohol testing do on the 3 M's? Not so hot. Research has continued to not show that it improves court appearance. It doesn't improve arrest-free behavior, and yellow circle, it's somewhat of a restraint on release or liberty, right? Because depending on the testing, you have to stop what you're doing, go get tested. Sometimes you have to give a biological sample, be observed, so it's intrusive. The star that's there is because research does show that drug and alcohol testing does do one thing, and it picks up a lot of compliance violations. Said differently, is we find that a lot of people will fail drug tests, but they're still coming back to court and abiding by the law. They're not picking up new arrests, new charges. So they're fulfilling the conditions of their release, right? The 2 big goals that was said at the beginning of our meeting, but we're picking up technical violations. So interesting conundrum, right? So they're doing the 2 big things we want them to do. They're just not very good at following directions, or they have a drug issue or behavioral health issue that's driving it, yet they're still making it back to court, for example. GPS, sort of the same. research has failed to show that it does not promote court appearance or law-abiding behavior. And again, we pick up a lot of technical violations, like a non-public safety related zone infraction. And of course, that assumes that the satellites and the technology is accurate. I've heard a lot of pretrial staff say that, oh yeah, sometimes it goes off, or the satellites aren't reading the zone correctly, so the person actually didn't screw up, but it says they did, or they don't charge the device in time, or whatever the issue is. So we pick up a lot of technical violations, but people will still often come back to court, not pick up new charges. And then, I saw in the chat that, using drugs can be a crime. Yes, if it's an illicit drug. Of course, alcohol is a little bit different, because once you're 21, that is lawful. A lot of people will drink a lot of alcohol and still come back to court, stay out of trouble. Just interesting. So this is just a summary of the research. I will say here before I show you the last line there that, and this is my opinion, you may differ, that I don't think there's enough research that says don't do these things with the red dashes. But I think there's enough research from studies throughout the country, different methods, different researchers, different populations, that says we probably don't need to do it as much as we think we need to do. Like, it's probably given us a false sense of hope and security, whether it's those of us in the system or victims in a case, that we're giving them sort of false assurances that this is going to help and work when it might not for most people. So again, it's a tough situation to be in, right? In my opinion, I don't think there's enough to say, oh, this is clearly saying don't do it, we're wasting time and money. But I don't think it should be categorical, and we're probably overusing it. Like, oh, everyone has a drug charge or a drug history, therefore they get testing. That's probably overdoing it. Most of those people won't need that testing to come back to court or stay out of trouble. And then lastly, secured financial conditions, making people pay money to get out of jail, has continued to fail. Research, this is pretty solid, almost as strong as court date reminders, that shows it does not promote court appearance. And higher amounts of money doesn't get us more court appearance. I know it's a little bit counterintuitive, but we have solid research now that shows that even though this is a very customary practice throughout the country, I know it's prevalent in Montana, it's prevalent where I live here in Colorado. Most states, not all, still use a lot of money bail, but it's not getting people back to court. The NA in the middle, not applicable, and I believe this is true in Montana law, that money is not related to public safety, meaning no matter what your bond amount is, if you go out and do a new crime and get arrested, violent, nonviolent, felony, misdemeanor, that you don't forfeit your money. Your bond may be revoked and you may be brought back into custody, but you don't lose the money. Or a bondsman or your family, whoever posted, they don't lose the money either. So you see, money can't motivate public safety. Now, the only thing it could do is it could be so high that someone can't post it that they stay in jail. Well, we're probably getting good public safety outcomes, but it's not the money, it's the detention. So you can see money's not related to public safety, not related to court appearance, where it doesn't affect it. And then lastly, of course, it has the opposite effect of maximizing liberty, because it causes a lot of people to stay in jail. All right, let's move on. Here's a summary. This came right around the time y'all went live in Montana. This was the case down in Harris County, the O'Donnell case. This is what Judge Rosenthal said. You'll see her quote here in the blue. She had experts come from all over the country and testify, from academia, from the commercial surety industry. They looked at reports, data, research, and this was her conclusion. And all the research since 2017 in the past 8 years has fallen in line with this summary. And that is, look, we make sometimes people pay money to get out of jail, and they get out of jail. They don't come back to court any more or less than people who don't pay money. And the person who pays $25,000 isn't outperforming the group of people who pay $5,000 or $10,000, for example. It just doesn't matter. That's what the research tells us. So, all right. All that research I just summarized, you can read it for yourself in these are written for practitioners. These were written 3 or 4 years ago, and they've updated most all of them last year. But you can see for yourself, like, well, what does the research literally say for court date notifications and drug testing? And like, how can I read these studies myself? They would be listed in these documents. It's not written for academia. It's written for those of us who practice every day in the field. So judges and lawyers, pretrial staff, court clerks, whoever might be interested. So I encourage you to check those out. And I'll make these slides available to Lisa afterwards, so you can always get them from Mike or Lisa at OCA. All right, second to final topic. Once we have the PSA scores, how does it affect release decisions? So think of it this way. We use the PSA to assess people. That's your first tool. We have an assessment tool. Then we have this thing called the pretrial release guide, or the matrix, to assist people. That's our second tool. So I have two tools. One to basically assess and the other to intervene. And all the matrix does is it matches people's PSA scores to default release conditions. What I would describe those as the starting point for how to think about what to do with these defendants if they're released. Remember, the PSA does not ever tell us what to do. If you hear somebody say that, please correct them. Oh, the PSA said we should release people. No, it didn't. That's impossible. It's just an assessment tool. Or they may say, oh, okay, no, sorry. We have this guidance. The matrix said we are supposed to release these people. No, that's not true. All it says is if we're going to release somebody, here's our starting point in our discussion and our thinking. Like, let's presume this level of release. We can go up or down based on the facts and circumstances of the case. So all it does is ground us in the default setting. So we don't have to just make it up, because when we make it up, we get lots and lots of over supervision. And we occasionally get people who aren't supervised or we don't intervene with who could have used the assistance. So it can go in both directions. Just trying to allocate our limited resources to the people who need it the most, right? Let's give the medicine to the sick people, not to the healthy people. All right, here is your Montana guide. I think James asked about this earlier from 2021. This existed in 2018. They made a few amendments. All this is saying is, if you look at it on the left, there's your 6 scores on the FTA scale, 1 through 6. And it shows the Montana success rate, and it gave the national success rate from like 10 years ago. And across the top, that's the 6 NCA scores, 1 through 6. And it provides a little map so you can go, remember that defendant, we saw his scores. He had a 6 on FTA, a 6 on NCA, he maxed out. So if you look at that, that takes us back down to the lower right down here, release level 3. If someone scored a 3 and a 2, that would be right here, release level 1, right? Lower scores get a lower level of release. As the scores get higher level of release, if they're released. That's right, some of these people will be detained, right? You will get some people with homicide charges or aggravated robbery, severe sex offenses, etc., who will score 1s and 2s. That doesn't mean the PSA is wrong. All it means is the person had a really high charge and they didn't have any of those other factors that contributes to their pretrial risk. They probably, a lot of those folks, as you know, have a job. They've lived in the community for a long time. They don't have prior history, so they don't have convictions or FTAs. They've never been in jail. They don't have other cases. They're probably a little bit older. So the PSA is accurate. It's saying if that person is released, they will probably perform like these percentages we see up here. That doesn't mean we should release them, right? That's the decision the court subjectively has to make. That's why we pay judges all that money, to make those tough decisions. All right. So keep in mind, both the PSA and the matrix does not recommend release or detention. It doesn't tell you to release or detain people. You have to do that under Montana law with the stuff that the judge is supposed to consider. Here's what the release levels mean. Levels 1, 2, and 3. Basically, it's saying, hey, no matter what your release is, you have to have, but you're going to always have basic conditions, right? I believe this comes from your statute. show up to court, abide by the law, keep in touch with your lawyer, and don't leave the state. Right? I believe in Montana, judges cannot unorder those things. Like it's just required of everybody, right? We call that a standard or required condition. Everything else, though, judges can add on if they think it will help this individual. Montana is in the process of working to give, hey, let's give all these people court date reminders. If they're under supervision, of course their case managers will remind them of court date. That's what case managers do, among other things. If you're level 2, here's the difference between 2 and 3. You'll check in with your case manager at least once a month, and this one's a little bit more, right? You're higher risk, so let's keep talking to you about maybe trying to help you do those things that make you lower risk, like remember your court date. Talk about and plan ahead. How are you going to get there? Do you have to get off work? Do you have to arrange childcare? Do you have transportation? It's in 2 weeks. Let's work on these kinds of things now, right? So we're not reacting after it happens. All right. And then secured financial conditions, it may or not be ordered for any of these cases. We talked about their ineffectiveness. And then other case-specific conditions, of course, they could be court ordered, like a no contact order is a relatively common. We would that's independent of level. So really all the matrix is saying is, look, if you're page, here we go. If you're higher risk, we're gonna keep in touch with you more frequently. If you're middle, it's medium. If you're lower, not much at all. Right? You're not ordered to supervision. Now, of course, a judge can always take level 1s and order them to supervision. I would just offer to you, have a really good reason for doing so, because pretrial services are limited. It's a limited resource, just like everything, just like the attorneys, the courts, the jail beds, everything. The more they spend time working on these people, the less time and money they have to work with these people. And these are the people who need it a little bit more. So again, exceptions are okay, but they should be relatively few and far between. More is not better. And say, well, I just look at charge, and if it's a high charge, I do supervision. It's like, you can do that, but realize you're asking pretrial services to provide a service to people. A number of those people don't need it. Just because they have a high charge doesn't mean they need supervision, right? What matters is, are they the whole picture of the person that makes them higher risk? How do we intervene with those people? And they tend to be over here. All right, someone asked about research on frequency of contact. Since Montana went live, we now have 2 studies, and this is covered in those research summaries. The studies so far have failed to show that more frequent contact matters more than less contact. What matters is we just do the contact. So thanks for asking that question. Said differently, those people who are level 3, if we have contact with them once a day, once a week, once a minute, once an hour, twice a week, at least, or all the way as little as once a month, it really doesn't matter what little research we have, that it's just having some contact with a person who's, again, working with you to help you get back to court. And that's really the biggie, right? Is problem solving with them ahead of time. You've got court next Friday at 10 o'clock in Missoula or in Polson, wherever, courthouses. How are you going to get there? Well, I do. It's like, yes, you have court. Well, I got to work. Well, let's work on that now, not Thursday night, right? That's what case managers should be doing, right? You problem solve, you coach and work with the defendants ahead of time. Same with law-abiding behavior. If we're just trying to catch people screwing up by testing them, or they're not checking in and go, hey, they're supposed to do this stuff, they didn't, I'm going to write a letter to the court. There's a emerging practice now, and soon to be research, I believe it'll come out early next year, showing that if we actually intervene with people differently, we don't see ourselves as trying to catch people screwing up, right? That's a little bit kind of the traditional probation model, but instead we see ourselves as, what's going on in your life that's making criminal behavior a little bit more likely? Is it behavior? Is it mental health? Is it substance abuse? Those are the 2 big drivers, right? Is it employment? Is it housing? Is it family issues? All the stuff that can contribute to affiliating with, other criminal people. all that stuff. That's the stuff we can intervene that has a chance to reduce criminal behavior, right? It's not just telling them to do something or not do something, and then when they don't, we either increase the bond or throw them in jail, right? That tends not to improve law-abiding behavior. So again, we could talk about this much more, but pretrial services has the opportunity again to intervene with people in the ways that actually help them come back to court and stay out of trouble. And then last topic of the day, meaningful first appearance. Again, this is something to aspire to in Montana and lots of other places. This is a neat little document. It's just a 2-pager. I believe, Lisa has this as well. And you may have it in your packet if this was sent around to you ahead of time. It's a neat little checklist to say, you know what, before that first appearance hearing, there are things that pretrial services, particularly OCA, could do. Defense counsel, the prosecutor, and the judge, there's things to do during the hearing. And if we do that, we will do a little better with due process, fair justice, protecting public safety, getting the right people in the right spot, be that jail or pretrial services or other community services, behavioral health, whatever it is, and keeping the people who don't need those things out of those things, which just is a waste of money. So the purpose of meaningful first appearance is to help toward those goals. So I'll end there. There's Mike's and my information. And any final questions before we wrap up today and Mike Farragher closes us out?
We have 1 minute, Mike, so I think I'm going to close this out. The final document packet is something that we prepared, our processors prepared to give you some more confidence in what we do. That's a list of the process they go through to determine the public safety assessment score. Also want the group to know that we've now completed over 40,000 public safety assessments. I've done none. They've done 40,000. And we do ongoing audits and reviews to ensure the fidelity of the public safety assessments. We know how critical that is for all the entities involved, and we certainly do not want to give a judge wrong information on public safety. So we work really hard on that. So our processors have all been with us over 5 years. So again, hopefully that instills more confidence in you that you're getting accurate and well thought through information on a public safety assessment. Vicki, I think if you put up the information about the CLE, is that on the
Yes, it's the first comment in the chat.
Okay, good enough, because I know people are interested in that. So with that, Mike, you did a great job. I appreciate it. Thanks for your participation, everyone. Dave, thanks for being with us today. So thanks again and take care.
We have a question.
Okay.
Yeah, I can stay around. Go ahead.
Go ahead.
Did we lose him?
We had a question.
Yeah, they're not muted.
Okay.
Mike, I don't see that CLE information anywhere on the
Oh,
notes, and it might not have been populated if you joined the group after like 11:30 or something.
Okay,
Okay.
I'll put it back on the chat
Hi.
again at the bottom.
thanks, Vicky. Oh, okay. Van Horn, are you back?
Can you hear me?
Yes, please, go ahead.
I'm wondering, now some counties use e-courts. Those e-courts are anyway affecting the FTAs, the FTA rates.
Is eCourt the software that sends reminders?
Not the full e-courts are not used anywhere nationally or statewide.
So tell me real quick so I can answer your question. What does eCourt do when you're thinking of it?
Electronic courts don't usually make decisions on the regular court decisions. Is not practiced anywhere nationally.
Okay. Yeah, I'm not familiar with maybe automated or AI type decision making. Haven't seen that yet. I know it's talked about. But I do know that there are case management systems used in our physical courts in different states and sometimes counties or large cities in certain states that do send out reminders to defendants like
Okay.
automatically. And that does that is shown that when you send out good remind, not all reminders are equal. Since sending out reminders can help, but you can send out high quality reminders that say certain words in a certain way, and people are more likely to come back to court, right? And that's very robust, and that works for a lot of defendants, no matter like what their charges were. If it's felony, misdemeanor, violent, nonviolent, like everybody benefits from that. So it's generally very low cost. Sometimes it's fractions of a penny for every text message you send out. And that can obviously, and for every FTA that's prevented, of course, we can save hundreds of dollars because of court time and attorney time and so forth and rescheduling. So again, high yield, low cost.
Okay, thanks.
Thank you. Yeah. And then, so Vicky's CLE information is now in the bottom of the chat. So please feel free to provide that information. Vicky, can you put your email in there as well? Oh, it is there. Never mind. I'm sorry. Yeah. So Vicky's email is in there. So just send Vicky an email with your information so you can get the credit. Any other questions? Before we go back to the rest of our day.
All right. Thanks again, everyone. Mike, thank you. And
Yep. Thank you.
take care.
Take care.